Hello everyone and welcome to Lawminds. So today in this video we'll be discussing about a very interesting topic, that is the doctrine of privity of contract. So as the name suggests, this doctrine comes under the Indian Contract Act 1872. So in this video we will be discussing in detail about this doctrine, its applicability in both Indian law and English law, and we'll be also be discussing the exceptions to this particular doctrine in this video. So let's start. First things first, let me give a brief introduction about this topic. So, we all know that one of the essentials of a valid contract is the presence of a consideration. The general rule in India is that, subject to certain exceptions, an agreement without consideration is void. Now, let us try to understand what the term consideration is, or what is the definition of the term consideration. Okay, the term consideration is defined under section 2 clause D of the Indian Contract Act. Now, this definition is as follows. That is, when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promisee. Now, to become a valid consideration, there are three requirements. The first requirement is that the consideration must be made at the desire of the promiser. The second requirement is that the consideration must be given by the promisee or any other person. And the third requirement is that this consideration must be a past consideration, or it must be a present consideration, or it must be for a future consideration. Okay, so these are all the requirements of a valid consideration. Now, one of the essentials that is to be satisfied to become a valid consideration, as I said before, is that such consideration must be given by the promisee or any other person. Now, this comes under the privity of consideration under Indian law. Now, let us move on to the topic, that is the doctrine of privity of contract. So this doctrine is very simple, it is very easy to understand. It means that only those persons who are parties to the contract can enforce the same. Now, for example, if A and B have entered into a contract, either A or B can enforce such contract and no other person. So, according to the doctrine of privity of contract, a stranger or a third person to the contract cannot enforce such contract. Even if there is a benefit which is conferred under the contract to this third person or to the stranger, he cannot sue or he cannot enforce such contract. This is the simple understanding of the doctrine of privity of contract. It is that simple. Now, let us try to understand the relationship between the privity of contract and the privity of consideration. I have already mentioned that there is a concept of privity of consideration under Indian law. Now, what is this? What makes these two concepts, or what makes these two things different from each other, is that under Indian law, it specifically provides, that is under section 2 clause D of the Indian Contract Act, which gives the definition of the term consideration. It is specifically expressed that a consideration may be given by a promisee or any other person. So under Indian law, a consideration can be given by a promisee or it can be given by any other person. So this is the privity of consideration, and this person who has given such consideration can also enforce the contract. Even if he is not a party to the contract, he can also enforce the contract. This is the simple understanding of the privity of consideration. Okay, now the privity of contract and the privity of consideration, the difference between this is that the privity of contract is applicable under both Indian law and also under the English law, but the privity of consideration is only applicable under the Indian law, because only Indian law gives scope for such privity in its which is expressly provided under the Indian Contract Act. So the rule in India does not affect the privity of contract. So in India, the privity is given only for the consideration of a third person. Okay, consideration made by a third person, even if such person is not the party to the contract. Okay, so this doctrine does not essentially affect the privity of contract. As I mentioned earlier, this doctrine of privity of contract is applicable both under the English law and also under the Indian law. But under English law, it is applied in a more stricter manner. That is, under English law, only parties to the contract can enforce the same. A stranger to a contract or a stranger to the consideration cannot enforce a contract, which is not the case under Indian law, because under Indian law, the doctrine of or the concept of privity of consideration is applied. Okay, now let us learn about the applicability of this doctrine of privity of contract under English law and under Indian law by using a series of decided case laws. Let us first take a look at this applicability of doctrine under English law. So the first case is Dweddell versus Atkinson. So in this particular case, A and B both got married, and A is the man and B is the girl, or A is the boy and B is the girl, and they both got married. Okay, but A's father and B's father, both of them entered into a contract stating that both of them will pay a certain sum of money or certain sum of allowance to A, and if there any failure occurs, then A can sue for the same. So after some time, or after the death of the fathers, there was a failure and A sued for the same. So here the court held that A is not the party to the contract. A's father and B's father are the parties to the contract, and A is a stranger to the contract. He is a stranger to the contract, and he is also a stranger to the consideration. So that apply the doctrine of privity of contract. Now the next case law is that Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited. Okay, this case reaffirmed the doctrine of privity of contract in its judgment. Okay, the facts of this case was that A was a manufacturing company and they sold the car tires to B, another company. Okay, with an agreement stating that, or both the parties agreeing that the tires will not be sold below the lowest price. Now, what did B do? B sold these car tires to C, another person, a third party other than the contract between this A and B. There was a third party, and B sold these tires to B, stating the same agreement between A and B, and C agreed for the same. Now, C sold the tires below the lowest price, and A sued before the court of law. Now, what did the court held in this particular case was that the court held that there was no contract between the A and C. The contract was between A and B and C, and there was no contract between A and C, and hence the doctrine of applying the doctrine of privity of contract, A cannot sue under this particular contract, or A cannot sue for the same. Okay, this was what was held in this particular case, that is the Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited. And hence, as per these two case laws, it is confirmed, or it is sure that English law strictly follows the privity of contract and does not recognize the privity of consideration too. Okay. Now, regarding the scope of this doctrine in Indian law, the doctrine of privity of contract is applicable in India also. Even though the Indian law under Indian Contract Act 1872 gives a wider definition of consideration than that which is given under the English law, Indian law also follows the common law principles of law, the doctrine of privity of contract, and this particular doctrine is applicable in India also. Okay, so let us take a look into two of the cases where this doctrine of privity of contract was applied in India. The first case is Jamna Das versus Ram Avtar. So in this particular case, there was A and there was B, and there was a property. Okay, now A, the owner of the property, he mortgaged this property to B, and A then sold this particular property to X by agreeing that X will pay the debts to B. So there was an agreement between X and A that X will pay off the mortgage debts of the particular property to B. Now B brought an action against X. But in this case, the court held that there is no contract between B and X do not have to undertake the liability or the undertake the mortgage liability on his own head solely because the property is being sold to him. So this particular case gave the judgment that there is no privity of contract, that is there is no contract between the B and X, and hence X is not liable to pay the debts to B. So this was what was held in this particular case. Now the next case is the Advertising Bureau versus C.T. Devraj. Okay, in this particular case, a circus owner has entered into an agreement with the advertiser, but when there was a failure in the terms of the contract and when there was a breach in the contract, the advertiser sued the financier of the circus. Now here in this particular case, the court held that the contract is between the circus owner and the advertiser and not between the advertiser and the financier, and hence the advertiser cannot sue the financier if there is a breach of contract. Hence, the doctrine of privity of contract is accepted under the Indian law, but the Indian law also gives scope for the concept of privity of consideration under Indian Contract Act 1872. Now, let us take a look at the exceptions to the doctrine of privity of contract. So, there are three exceptions. The first one is that the trust of contractual rights or beneficiary under a contract. The second exception is the conduct, acknowledgement, or admission of the promisee and the promisor, and the third exception is the provision for marriage expenses or maintenance under family agreement. So these are all the exceptions to the doctrine of privity of contract, and let us take a look at each of these exceptions one by one. Okay. Okay, so the first exception regarding the doctrine of privity of contract is the trust of contractual rights or beneficiary under a contract. So, under the Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited, in this particular case, the court stated that a right to sue is conferred on a third party only by way of property, as for example, under a trust. So this means that if in a contract the subject matter is a property and this subject matter of a property is in the form of a trust or in any other similar form, then a third person who on whom such rights is conferred or on whom such benefit is conferred out of that trust, even if the third party or the person is not a party to the contract, he can sue or he can bring an action before the court of law against such contract if there is a breach. Okay, so this is the first exception to the doctrine of privity of contract. Now, the basis of such an action is not the enforcement of the contract, but the basis of such action is the enforcement of the right conferred by a particular contract in favor of a third person by way of trust. Now the question as to whether there is a trust or whether there is a right conferred by a particular contractor or whether the third person can bring an action, all of these questions, the solution to all of these questions depends on the facts of each case. In India also this exception is applied under various case laws. Now the first case is Khwaja Muhammad Khan versus Hussaini Begum. This case is regarding a Mohammedan marriage contract. So in this particular case, the contract was entered by the plaintiff and the defendant's father. So, as per this contract, the defendant's father stated or the defendant's father has agreed that if the plaintiff marries the defendant's son, then he will give or he will allow a pocket money in the form of an allowance to the plaintiff, and also a property will be set aside for the benefit of the plaintiff. Now, after the marriage, the defendant's father failed or did a breach to the contract, and the plaintiff brought an action against the defendant, that is against her husband for such breach. Here, in this case, the court held that the conferring or the when there is a subject matter, the property is the subject matter. In this particular case, this property acts as a trust for the plaintiff, and in such a case the doctrine of privity of contract does not apply in this particular case, and the defendant is liable for the breach of the contract. So this was what was held in the Khwaja Muhammad Khan versus Hussaini Begum. Now the next case is regarding the Narayani Devi versus Tagore Commercial Corporation Limited. In this case, the court held that this case was decided by the Calcutta High Court, and in this case, the court held that from the facts and circumstances of the case, an obligation in nature of trust can be inferred in favor of plaintiff, and she is entitled to her claim even if she is not a party to the contract. Now, the facts of this case is that A has certain sum of shares in his under his ownership, and A agreed to sell this shares to B, and C acted as the security for such an agreement, for such a contract for the party B. But here the agreement was that the B has to provide certain alimony or certain amount per month, a certain sum of amount per month to A in his lifetime, and after his lifetime, he has to provide a certain amount of money to his widow after his death. Now, in this particular case, the both B and C complied with the agreement. They provided A with a certain sum of money during his lifetime, and after his lifetime, they provided a certain sum of money to his widow also. But when there was a breach occurred, the widow or the X is the wife of A, and this widow sued a file against this B and C for the breach of the contract. Now the court here held that the arguments of the defendants was that there is no privity of contract, that is the contract was entered by B and C with A and not with A's wife X. So there is no privity of contract. But here in this particular case, the court held that the facts and circumstances of the case are in such a nature that it forms a kind of trust, and when a trust is formed in favor of the plaintiff, in such a case she is entitled to her claim even if she is not a party to the contract. So this is the exception of trust of contractual rights or beneficiary under a contract act. Okay. Now the next exception is regarding the conduct, acknowledgement or admission of the promisor. So sometimes there may not be any privity of contract between the parties, but if one of the parties by his conduct or acknowledgement or admission recognizes the right of the other party to sue him, he may be liable on the basis of the law of estoppel. Now let us take a look at the same case, Narayani Devi versus Tagore Commercial Corporation Limited. So in this particular case, the defendants, that is both C and B, had paid this certain sum of money to A in his lifetime, and then after his lifetime they provided this money, or they paid this certain sum of money to X, the A's wife, after his lifetime. Okay, they also made provisions, or they also made documents regarding the same. So by their conduct, they have acknowledged or they have admitted that there is a contract, or the X is also a party to a contract. She is also getting some benefits out of the contract, and by their conduct and their acknowledgement and their admissions, they created a privity of contract with the plaintiff, and hence even if the plaintiff is not a party to the contract, she is entitled to get the claim, or she is entitled for the claim under the contract. Okay, so this is the second exception to the doctrine of privity of contract, that is the privity of contract by the entering of privity, creation of a privity of contract by the act, acknowledgement or admission of the promisor. Now, the third and final exception under the doctrine of privity of contract is regarding the provision for marriage expenses or maintenance under the family agreement. When it comes to the family agreements, then the doctrine of privity of contract may not apply. Okay, so under a family agreement, the contract intended to secure a benefit to a third party can sue, such a third party can sue in his own right as a beneficiary. Okay, so the best example for this exception, to understand this exception, is regarding the partition cases of joint family property between male members. Then in such cases there will be a provision made for the maintenance of the female members. Okay, and this rule or this provision is regarding or is a result of the rule which was made in the Khwaja Muhammad Khan versus Hosseini Begum. This case was discussed earlier. So as per this rule, this exception is made into force. Okay, now the next case which comes under this exception, where this exception was applied, is in the case of Veeramma versus Appaya. So there was a family arrangement that the father's house is conveyed to the daughter, and the daughter has to maintain her father in his lifetime. So in such a case, the court held that the daughter can entertain a suit because she is a beneficiary, or she gets certain benefits from the father's property, and she will be a beneficiary, and she has the right to and right for enforcement of specific performance of contract. This was held in the case of Veeramma versus Appaya. Now the next case is Sundaraja Iyengar versus Lakshmi Ammal. So okay, so in this particular case there was a partition deed between the male members of the family, and this partition deed made provisions for the contribution for the expenses of marriage of the plaintiff by the defendant, that is by the plaintiff's Lakshmi Ammal's fathers and brothers. So in this case, there was a breach in the contract, or there was a breach in the partition deed, and Lakshmi Ammal went for a case, sued a case against her, against the defendants. So in this particular case also, the court held the same decision as the Veeramma case. The court held that Lakshmi Ammal, being a direct beneficiary of the contractor, she has the right to sue the defendants as per the provisions of the contract. Okay, now the next case is Manali Singhal versus Ravi Singhal. So this is regarding the contract or the marriage settlement between husband and wife for providing maintenance to the wife. So in this particular case, the court held that such contracts cannot be hit by section 25 on the ground that the same is without consideration. In these cases, the consideration is love and affection, peace and harmony, or satisfaction to flow therein, and there is a consideration, so it should not be hit by section 25. So these are all the exceptions to the privity of contract. Okay. So now in this particular video, we have learned what is the privity of contract, what is its applicability under English law and Indian law, and what are the three exceptions to this particular doctrine which are established under various decided case laws. We have looked into these particular case laws one by one, and to understand these exceptions and to understand the concept of doctrine of privity of contract. So doctrine of privity of contract simply means that only parties to a contract can enforce the same and no other person. Okay, it is recognized and applied by both Indian laws and English laws, but Indian law recognizes the privity of consideration because it is specifically given under the section 2 clause D of the Indian Contract Act 1872, and we have also learned the three exceptions of the doctrine of privity of contract. So this was all about the doctrine of privity of contract. I hope this video was helpful. So if you like the video, please subscribe to the Lawminds channel. Thank you.